They're going to argue in their closing statement, this was a heat of passion. This was not intentional. This was not premeditated. The prosecutor doesn't know what he's talking about. There isn't any type of evidence except for the prosecutor's claim, and there isn't direct evidence that this was premeditated. However, as Prosecutor Juan Martinez stated in his closing argument, you just need to have firmly conclusive evidence. That's what he told the jury. They did not have to have a direct link of everything that he's spoken about the gas cans, about the hair being blonde, about the rental car, about the gun. So this may be first degree versus second degree. Sometimes what happens in these situations is they don't get the information until later. And by law, they have to go out and do some type of an investigation. The issue here is, well, you can do your investigation, but why did you have to take the baby? You can still do the investigation while the child is there, while the child is with the parent. You have documentation from the hospital, which was Kaiser Permanente at the time, that says this baby's been discharged, the baby's okay. Go to the hospital. You can investigate people there, doctors there, whoever discharged the child. This is what happened in this situation. The parents went against the doctor's advice at Sutton, the first hospital, and they just left without the child being discharged properly. What could have happened was the parents probably felt they weren't being respected. People were not answering their questions. Right. And so they just said, look, we're going to take the baby and we're going to go to a hospital and we're going to get a second opinion. Now, what I have seen happen in these situations is you can tell the hospital, we'd like to have our child transported to another hospital to get a second opinion. Sometimes, and most of the times, you have to have the hospitals cooperate with you because you're not refusing medical treatment here. You just want a second opinion.